I'm Darren Feinblum, and I'm one of the partners at Feinblum and Hanel. For the last 10 years, I've dedicated my practice to defending people charged with DUI offenses. Let me talk to you a little about the process. What generally happens is after you're arrested, you're given what's called an arraignment date. The arraignment is the first day to answer the charges. Once we're on board and you hire us, we go to work immediately. And you say, well, what do you do for us at Feinblum and Hanel? Well, what we do for you is we get all the evidence. And that includes videotaped evidence of the jail. We want to see what you look like shortly after the arrest. That's especially important when the police officer has no videotape of your field sobriety test. So at that court date, the arraignment, you will not need to be there. In fact, I won't be there either. All that will be there is my paperwork. In the meantime, while we're waiting that court date, we're requesting all the evidence that the state attorney's office has in their possession. We're also going to request evidence they may not have in their possession, like I talked about before, videotaped evidence of the jail, any 911 calls, your medical records. You're seeing a nurse. We want the nurse's opinion as to your impairment because that is an unbiased person who's making a decision about whether you're impaired or not. We are building your case from day one, and that's the only way to fight these DUIs. They are some of the most complicated cases we have in the state of Florida, especially as a misdemeanor. So the arraignment date, the judge will read out your name. He'll say it, or she'll say, you're represented by Feinblum and Hanel. Let's move it on to a pretrial conference. At the pretrial conference, myself or one of our team of lawyers will go on your behalf. You will not need to be there, although you're more than welcome to come. Sometimes our clients want to see what's going on. It really will have little to no effect on your case, but we're happy to keep you up to date. What will happen at the pretrial conference is we'll let the judge know where your case is going. Is it something where we have motions to file? Have we gotten the case reduced? Have we gotten a resolution that doesn't include any jail time? Those are all things that we're going to let the judge know at your pretrial conference. A couple things that can happen. We can set it for a plea. We can set it for another pretrial conference while we obtain the rest of the evidence, or we can set up a trial. We're not scared to try a case here at Feinblum and Hanel. We've had 3 in the last week. So we're definitely not afraid to fight for your rights. What I think is important that we need to do is you need to tell us exactly your feelings, and then I'll give you my opinion as to whether I can win your case. And I'll be honest with you, and I think that's what you want out of a lawyer. But I will tell you what your chances are of victory in your case. Where there's a will, there's a way. And you need to be honest with us, and we'll be honest with you as to what the chances of success are. If the case does get set for trial, let me give you a little bit of a synopsis of how that would go. What happens first of all is we pick a jury, and that includes 7 people from the community, 6 jurors and 1 alternate. The questioning goes something like this. The state attorney's office gets to question the jurors, and I myself gets to question the jurors. And what we want to try and do is get together the fairest possible jury for our case. And that's obviously hard to do, so we want to find out as much information about these jurors as possible. As you know, DUI is a very, very serious offense, and some people have strong feelings towards it. We need to find that out so we can get you a fair jury. What happens is then we go immediately into opening statement, and the state attorney's office will lay out what they believe their case is. We will then lay out what we believe our defense is. In an opening statement, we want to give everything away. We want to give the jury pieces of our information, how we're going to prove that you're not guilty of the DUI. Then we go into the rest of the trial where the officers testify, and we put them through a rigorous cross-examination. I have cross-examined upwards of 60 police officers on DUIs. Very familiar with how to do it, and I'm very creative in how I show the jury that you are not guilty of DUI. We finish up potentially with your testimony or any witnesses on our behalf, and then we go into closing arguments. After the closing arguments, the case is submitted to the jury, where the jury will determine whether you're not guilty or guilty. That can take anywhere from 5 minutes to 5 hours. It's a stressful time, and we know that you're stressed. And we're going to do everything we can to prepare your case to our fullest. We are here for you when no one else is. If you've been charged with DUI and you want to fight your case, we're the team for you. Give us a call at 1-800-FIGHT-IT or visit our website at fightyourdui.com.